Good morning, Your Honors. Catherine Oren for Christopher King. May I begin by correcting an error in my brief, please? My sister's quite right that a review proper in this case will be for any substantial risk of a miscarriage of justice. I can report having done everything I can to reconstruct counsel's request for jury instructions. And at the hearing during those reconstruction efforts, the court repeatedly credited counsel's representations. But my sister's right. On page 16 of that hearing transcript, the court leaves the door open to the possibility of error and doesn't accept the affidavit. So my reconstruction labors have failed, and the error under Biancardi can't be considered preserved for review. I can offer, though, two silver linings. The first is that this doesn't change Mr. King's argument. In his brief, he does urge that even assuming that the jury charge error is unpreserved for review, given the physical attack he was obliged to repel in this case and the circumstances in which it occurred, failing to explain the law of self-defense substantially risked a miscarriage of justice. Now, the only question before the jury in this case was who assaulted whom. And that question assumed a razor-sharp edge from the outset, because people immediately assumed Christopher King was a criminal because he was hurt less seriously than Christopher Garden. That assumption, though, finds no support in logic and law. Injury didn't negate Christopher Garden's intent to assault Christopher King. And that's what made self-defense instructions so crucial in this case. Mr. King's sole hope at exoneration was to have informed fact finders apply the settled law of self-defense to what happened to him that night. And they couldn't do it because the court never mentioned that key law. Now, that dismantled the defense. The very purpose of self-defense instructions is to guide jurors in very practical terms, step by step by step, through complex analysis by which the law distinguishes between a criminal assailant and his victim. And those instructions function in very specific way by obliging fact finders at each step of this multi-part process to issue specific findings needed to allocate criminal blame. Now, those analytical guideposts, the elements of self-defense, with one exception, were not before the jury, which leads me to my second silver lining. There's no dispute that failing to explain self-defense in this case was error. And there's no dispute that that error was apt to have materially affected the jury.
Well, there is I thought that the appeals court said on that, no, it wasn't.
No, the appeals court said it was apt to materially affect things. It's just the question, who was harmed by it? The appeals court, everybody agrees that when as here, all the facts viewed in the light most favorable to the defense create a reasonable doubt about the elements of self-defense, complete instructions must issue, because when the facts do that, self-defense is the crux of the case. And any confusion in that regard directly strikes at the crux of the case, and that substantially risks a miscarriage of justice. So we all agree there was an error, and we all agree it was apt to affect deliberations. The only dispute about is whom the error hurt, and here people do part company. The two appeals court justices accepted my sister's argument that the error damaged the Commonwealth alone by denying it multiple grounds on which to prove guilt. Now, I understand that that argument is twofold. On one hand, the error damaged the Commonwealth alone because it gave Mr. King all but one element of his defense. And on the other hand, more specifically, even though Christopher King was completely blocked in physically on all sides, the fellow one step behind him worked with him and was therefore biased in his favor. And for that reason, properly instructed jurors might well have required retreat through that biased witness before deeming responsive force towards Christopher Garden permissible. Now, for two reasons, Mr. King asks this court to reject that conclusion. On one hand, as a matter of logic, the error couldn't give Mr. King anything. Omitting required analysis cannot furnish omitted analysis. This wasn't a bench trial. Whatever about the elements of self-defense was so settled in the judge's mind that he didn't even think the jurors needed to bother with that part of the analysis. That assurance did nothing to instruct the actual fact finders in the case about required law on which their determination of innocence and guilt turned. Now, with respect,
what part of the model jury instructions do you say should have been given that wasn't just the two ways in which the Commonwealth can show that self-defense does not apply, or is there something else?
Well, and the only thing that was stated was the force can't be disproportionate. Right. Everything else was omitted. That's absolutely correct.
Both proves beyond a reasonable doubt that
right.
unreasonable force was used, then the defense fails.
Absolutely, unquestionably so.
So are you just saying the court should have also instructed that?
Well, basically, here's the concern, is that the jury instruction removed the proper focus of deliberations from the jury. And by doing so, especially when joined with the Commonwealth's closing argument, it virtually assured conviction on unlawful grounds. The proper focus of deliberations in any self-defense case are essentially the causes of responsive force. So narrow circumstances in which the law deems responsive force reasonable. So there must be a reasonable apprehension of an imminent threat to personal safety. There must be no reasonable means of physically retreating, and there must be no reasonable grounds for belief that anything short of force will repel attack. And these three things the law recognizes as legitimate causes of defensive force. Now, that causal analysis was removed for the jury, and that's a conceded violation of settled precedent. Jurors can't reasonably be expected to understand that matters never even mentioned as legally relevant were actually the crux of the case. Now, by removing that crucial causal analysis, jurors were bound to focus on what was dramatically before them, and those were the effects of responsive force. So one man fell and the other man didn't. And the man who fell was hurt substantially more seriously than the man who didn't. But that's irrelevant to the only question before the jury in this case, which was who assaulted whom. The relevant question in that context was the quantum of force to which Mr. King resorted. Here, a punch for a punch. So to secure...
there are two arguments which were made by the dissent and which you're making here, and I'm speaking of Justice Cordy's comment. One is that you're saying there should have been some instruction that said the key here is excessive force, not necessarily the severity of injuries, correct?
No, I'm concerned that this jury is never, that the point of self-defense instructions is basically to put the jury in Mr. King's shoes, to force them to scrutinize very closely circumstances that he confronted in order to determine whether his decision to resort to force was a reasonable one. So the other factors, the other elements of self-defense, force them to scrutinize step by step by step the legally material circumstances that confronted Mr. King that night and whether his decision to resort to force was reasonable. So disproportionality, that's just part of it.
But I'm trying to understand. Are you saying that the judge erred by not saying that the focus is on the reasonableness of the force and not the severity of the injuries? Are you saying that that's not part of your argument?
Right. No, it is. I mean, the judge, he's obliged to instruct about the proportionality of force used. I don't think there's any obligation for him to say it's not the effects that are relevant. Just make clear that it's the proportionality of force used.
So,
my concern is...
Are you saying that the first two elements that he didn't give that go to its excessive force in relation to what, and in relation to what makes you look at whether you have a reasonable the circumstances that may give you a reasonable concern for your safety, and
Exactly.
the circumstances that may look at why you couldn't escape, that
Right.
kind of thing?
Exactly. I mean, basically, each element of self-defense is so inextricably intertwined causally with analysis of the others that considering each entails consideration of the others.
So what if the judge had given three elements of self-defense, but in the first, instead of saying that the defendant had reasonable concern for his personal safety, if the judge had said that the defendant believed that he would suffer either death or substantial bodily injury?
Well, that's deadly force. I mean,
Yeah. Well, so what if the judge had given that instruction? Would you be making essentially the same argument, that he had misinstructed and that the jury could not stand in the shoes of the defendant?
Well, I mean, it would be a substantial misstatement, absolutely. I mean, I'm wondering, in that circumstance, it would definitely, it would prejudice Mr. King. They're saying for him to resort to force, he had to believe he was on the point of dying. Sure, that's objectionable. You know, that would be incorrect. There's no deadly force.
But would that entitle him to a new trial?
Well, it would certainly entitle him to proper instruction of the jury. You know, declaring a mistrial, yeah, I mean, if the judge refused to correct, if the judge insisted on issuing a deadly force instruction, yeah, that can't be. That's not the standard in this case. So I'm not sure that I'm understanding the question. It's simply not a deadly force case. If he had insisted on the standards for deadly force, yeah, there would have been an objection, because that's simply not the standard. Now, I mean, the question that I have is just also the contention that properly instructed jurors might have required retreat through Sean Griffin. That's highly uncertain. It's sufficiently uncertain that it's properly entrusted to jurors, fact finders requested when Mr. King asked for a jury trial. Sean Griffin himself insisted. Mr. Garden allowed Mr. King no time whatsoever to react. And even if that retreat had been possible, it would have required knocking Sean Griffin to the ground. Now, setting aside the temporal impossibility here, I find no precedent requiring that kind of risk to innocent bystanders before self-defense becomes permissible, and it's highly unlikely that the jury would have invented that requirement. So weighing, that's the theory. Why, had jurors been properly instructed, the court would have called the case, the jury would have called the case in the Commonwealth's favor. And I'm concerned that's very unlikely. The idea that omitting required analysis could possibly give Mr. King anything, that is as a matter of logic, is untrue. And the idea that they would have required retreat through Sean Griffin, that's very, very unlikely. But by contrast here, he was basically, the relevant causal analysis was completely removed. They had no choice but to focus on the offense and misapply the proportionality instruction to what was plainly before them, named expressly as a legally relevant factor, and that's the disproportionate use of.
But the judge, in his instruction, or his or her, I forget whom, you may also consider the availability of room to maneuver or the means of escape from the
So
area
that's
in
the
question.
Kendrick language, absolutely. So there's Kendrick language in this instruction, but that language is unquestionably a proper supplement to instruction in the law of self-defense, but it can't supplant it for at least two reasons. So it doesn't reach all the elements of self-defense. And on the other hand, it in isolation, it actively misrepresents required analysis. So the first and foremost consideration in any self-defense case is that the person who resorted to force reasonably apprehended an immediate threat to personal safety, and that's not part of Kendrick at all. Now, additionally, Kendrick permits jurors, in their full discretion if they want to, when determining proportionality, they can consider, like as Justice Gans says, the room to maneuver or to escape. That's not the required analysis, though, under cases like Harrington, Schaefer, and Franchino. Scrutiny of the defendant's trapped circumstances is mandatory part of self-defense analysis. If he's not trapped, there is no self-defense at all. So for those two reasons, the language from Kendrick can't possibly cure the error here, and there doesn't seem to even be a dispute that it can. There is no dispute that there is an error. There is no dispute that it affected things. The only thing is, who did it hurt? And in the balance of damage to the two parties, I would strongly urge that it was the defendant who was much more likely to be damaged by this partial instruction than the Commonwealth. By being denied the opportunity to argue, he should have run Sean Griffin down to get away first. So this is why Mr. King is before the court this morning. He's asking, beyond being threatened and then a week later punched in the face in a bar, he was immediately declared a criminal. He was tried, convicted, and sentenced, and literally the fact finders never knew required law on which their determination of innocence and guilt depended. And it's for this reason he's asking the court, before final judgment enters, may inform fact finders apply settled law to what he confronted that night and issue a reliable determination of whether his response to Christopher Garden's repeated aggression could possibly be deemed criminal. If there are no questions, I cede the floor to my sister.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Elizabeth Martino on behalf of the Commonwealth.
Wouldn't you say that it is a fair observation that this instruction doesn't really explain to the jury when it is that someone can act in self-defense?
Well, I actually would disagree with that. If you look at the very beginning of the instruction, the judge says, evidence in this case has been offered that the defendant acted in self-defense. In sum, a person may lawfully use reasonable force to defend himself from physical attack. And that is exactly what the model jury instruction says. It
says for the defendant to have acted in self-defense, this is the model jury instructions,
Right.
For the defendant to have acted in self-defense, he must have reasonably believed that he was being attacked or was immediately about to be attacked, and that his personal safety was an immediate danger.
Right. So
And that's a little better of an explanation than this. I mean, it's a lot better.
But essentially, I think that the judge does explain to the jury, look, the defendant is entitled to use self-defense, use force to defend himself from physical attack. It's essentially the same as what the model...
When he reasonably, or when he is either being attacked or reasonably believed he's about to be attacked, or that their personal safety is an immediate danger. I mean, it's a... I don't know. I mean, you have to admit, the model and jury instruction really does explain this, when it is the defendant can use self-defense, much better than this instruction.
And doesn't that go to being able to I mean, doesn't what Justice Cordy just read go to being able to analyze whether it was or wasn't excessive force? I mean, doesn't that bear on it, those other factors?
Well, I don't think there are other factors. I think the model jury instruction says the defendant has a right to use self-defense if he reasonably believes he was being attacked or about to be attacked. And the judge said the defendant may use, a person may lawfully use reasonable force to defend himself from physical attack. So I don't see that it's much better. I think that the nature of self-defense was explained to the jury. Look, a person can use force to defend themselves from physical attack. The judge placed the burden at all times on the Commonwealth to disprove self-defense. The judge said, you know, he can use force to defend himself from physical attack, and then explained what reasonable force is, that he may use no more force than reasonably necessary under the circumstances. Here's how you assess whether the force was reasonably necessary under the circumstances.
Well, Judge Drebin makes the point that the judge did not inform the jury what standard was to be used in assessing what force was disproportionate. And so what do you say about that? I mean, the prosecutor, she said, his closing argument emphasized that the victim suffered serious injuries compared with the absence of any harm to the defendant. And if the judge didn't explain how to assess this disparity, didn't it leave it up to the jury to just count up who was most injured and conclude that that meant that person was the aggressor?
No, and I would sort of just disagree with the characterization of the Commonwealth's closing. The closing was, the Commonwealth's theory of this case is that the defendant sucker punched the victim, right? That there was no sort of fight, that the defendant came up and he was mad about what had happened the week before, so he just sucker punched the victim, and that's an assault and battery. But if you believe the defendant's version of events, it was that, you know, the victim hit the defendant first. And then the prosecutor said, but you know, by the defendant's own words, he didn't have any injuries. He was standing upright after he was hit, and in retaliation or in response, he hit the victim with such force that the victim went flying and got all these injuries. I think that the injuries were just used to show the disproportionate force, to illustrate the disproportionate force used by the parties, if you believe the defendant's version of events. That was the closing argument. And if you look at the judge's instruction, which is included in my brief at page 21 and at transcript volume 2, 86 through 87, I think the judge does explain how to assess excuse me, whether the force used was reasonable. The judge says a person may use no more force than is reasonably necessary in all the circumstances to defend him or herself, which is in accordance with the model jury instruction, and then says it cannot be manifestly disproportionate. You can consider the reasonableness of the defendant's conduct, evidence of the relative physical capabilities of the individuals involved, how many persons were involved on each side, the availability of room to maneuver, the means to escape. So the judge really did explain what the jury needed to consider. I think that the thrust of the defendant's claim in this case is that the fact finders, the jury, were left without any context to understand self-defense because they weren't given the model jury instruction, and I would argue that that's just not the case. If you look at the judge's instruction, he says, first off, look, the defendant can use force if he believes he's being physically attacked. And that is the nature of self-defense, and then goes into what force is reasonable. The only thing the judge did not do was say, as the model jury instruction instructs, there's 3 requirements that the defendant must meet in order to properly exercise self-defense, 1 and 2 and 3. And if the Commonwealth disproves any one of those, then they've proved that the defendant did not use self-defense. He didn't do that. He gave the Commonwealth an all-or-nothing strategy. He said, they've got to prove that the force was reasonable, or you must find the defendant not guilty. And I agree that that was an error, but an error that prejudiced the Commonwealth. And I think that that's illustrated by the fact that the prosecutor was saying in his closing, look, you know, we can disprove self-defense by showing that the defendant could have used, you know, escaped, and he didn't here. And then in the judge's instruction, he totally took that away from the Commonwealth as a theory to disprove self-defense.
Yeah. But all the elements that are involved in a proper instruction talk about reasonableness, a reasonable concern for personal safety, a reasonable means to avoid physical combat, and no more force than was reasonably necessary in the circumstances. Don't you need the context of all three of those in which to determine whether the defendant used reasonable means or had a reasonable concern in order to evaluate the reasonableness of each of the elements?
Well, I would say here the judge did instruct a person may use no more force than is reasonably necessary in the circumstances, and then went through all of those things: maneuverability, ability to escape. I mean, did speak about all of those things. The only thing the judge didn't do was explain them as a way for the Commonwealth to disprove that the defendant used self-defense. I mean,
did he say reasonable concern for personal safety?
He says a person may lawfully use reasonable force to defend himself from physical attack. So he didn't say, he didn't use those words, but I think the thrust was the same, that you know, a person can use self-defense when they're being attacked. And the other thing is, I think it is possible to envision a scenario where one of those self-defense requirements just shouldn't be given. For example, if the defendant and victim were fighting in a closed elevator, and you know, there's no question that the Commonwealth couldn't disprove that the defendant could have reasonably escaped. It's a closed elevator, and the only question is, was he being attacked, and did he use reasonable force in that attack? I mean, I think under that circumstance, certainly a judge wouldn't have to explain, well, he also had to use all reasonable means to escape, because there's no way the Commonwealth could disprove he had any reasonable means to escape. So there are scenarios where the judge wouldn't have to give all three, and it doesn't automatically, you know, deprive the defendant or the fact finders of ways to understand whether self-defense was properly exercised. And if the court doesn't have any other questions, the Commonwealth would rest on its brief.
All right, thank you.
Thank you.
We'll take a brief recess.
All rise.